for the tardy start. Technical glitches did take some of our precious time, but it is my hope to present to you some stellar information so that you can move forward with the topic at hand. Today, it's the second part of the Law and You series presented by WIABDA. I am Melnia Cordes, principal at Melnia Cordes Law PC. And we'll be dealing with the topic of rent arrears, evictions, and court actions post-COVID-19. We are all familiar with the economic impact of the New York shutdown on families here in New York, not just residents, but commercial occupants of New York. And today, this forum is to present some information to you on how you can deal with rent arrears as a tenant, also how you can deal with possible court actions if you're facing litigation for demands of rent and or evictions. We have a stellar panel. Mr. Terry Hines has over 17 years of experience as an attorney at law. He primarily practices in the area of landlord and tenant, and he will be addressing us from a landlord perspective. Also, we have Ms. Christy Ortiz-Lam. She is the executive director or the deputy director of preservation at the Brooklyn Legal Services Corporation. She has been there for 5 years, and she will represent the tenants bar, and she brings a wealth of knowledge and experience with respect to what tenants can do when they're facing rent claims, rent arrears, and court action. Finally, we have the esteemed judge, Cheryl Gonzalez. She is the supervising judge of the Brooklyn Housing Court, also known as the Kings County Civil Court Housing Court. Judge Gonzalez has been a judge in the housing part since 2005. She has been promoted to the supervising judge, and she brings a wealth of knowledge and experience, both as an attorney and as a judge to this forum. She will provide us with knowledge and guidance and instruction as to what we can expect with respect to what goes on in court and how to deal with the court matters from a judicial perspective. Thank you all for participating here. And I will first like to invite Mr. Hines, private practitioner, to present perspective from the landlord's bar with respect to what landlords can do if their tenants owe rent, what steps can be taken if they want to evict their tenants, and what recourses are available with respect to court action. Mr. Hines.
Thank you so much. Good afternoon, everyone. I'll first start by saying that this has to be the most challenging time to be both a tenant and a landlord. I think from the perspective of small homeowners, those who own properties 4 units and below, many have felt for at least the beginning of the pandemic like the forgotten bunch. All right, there was a lot of legislation, there was a lot of talk around assisting tenants. And what I always say is that the relationship between landlords and tenants are a symbiotic one, where if one party suffers, especially with small landlords, if the tenant suffers, a landlord is usually going to feel that effect. And if you take where we are now, many small landlords who are considering or who are in legal action haven't received rent for over a year. You know, the usual adage was, as a small landlord, that you put aside 6 months worth of rent, use, and occupancy in case of an emergency. We've gone so far past that it's scary. I will say that I have been heartened by the recent legislation which has taken place, which addresses the issues of the landlords as well as the tenants in terms of setting aside a moratorium. If you're a landlord, you can actually apply for mortgage for forgiveness. How that's going to work and how that's actually going to roll out is something that we need to actually see. I've been getting a lot of calls from landlords who are concerned or really confused. When we first had the moratorium, no action could be started at all. And the issue was when they extended these moratoriums, whether the landlords could actually proceed with court cases. So a lot of the calls that I receive are from landlords who are questioning whether or not they can even start a case, right? The answer to that is yes, you can proceed with the case. But as you'll hear as we go through this discussion, there is a huge backlog as to where we are presently and what it's going to take to actually get back up to speed. So the difference between actually starting a case and actually having that case heard or having a remedy, that's something that's yet to be seen. There will be also some discussion, and I am also heartened by the $2 billion which has been put aside for rent relief, which will be assisting, tenants and in result assisting landlords who accept those monies. There are several caveats that come with that. For instance, a landlord who, at least that's what's being discussed, is a landlord who accepts the monies, which would cover basically monies from the beginning of the pandemic in March of 2020 until present. Landlords who accept those monies would be precluded or prevented from actually starting any legal action against that tenant for a year's worth of time. In addition, I think the tenant doesn't need the permission of the landlord to actually apply for those monies. And the landlord, I think, also can apply for those monies should they so choose to do so. One thing to think about as well is that as a landlord, if you say, well, look, I want this tenant out, I don't want to take the money, I just want to continue with the case. If you deny the money, if you reject the money, you also will be prevented from getting those monies in a civil proceeding or any other proceeding. So it's really something to take into consideration. So long story short, there is a lot of ambiguity going on right now. There's a lot that's up in the air, but as a landlord, I would say that if you're going to start a case, and not to like toot my own horn or anything, but I would highly recommend, especially in the environment we're in now, that you get the assistance of counsel, because right now it's not as straightforward as it used to be. There's a lot going on. There's a lot up in the air. Thank you.
Okay, so Terry, I just want to clarify, if the tenant owes rent, it is okay for the landlord to send that rent demand to the tenant in this climate?
That is correct. And now one thing that I should also notice, which I didn't, is that any document you're sending is going to also have to be accompanied by a hardship declaration, which basically would state to the tenant that should they feel that they were affected by COVID, either that they would be affected by moving, if they had to move, would be affected by COVID, or that they suffered a reduction in income due to COVID. If they fill out that declaration, even at this stage, said case would be adjourned until at least the end of August.
Okay. And for those instances where a tenant is destroying the premise, is there any recourse that's available to a landlord?
That's a great question. You can, if you're a landlord and you're in that situation, you can apply for, when the tenant sends back, say, this hardship declaration, you'll be able to state that the declaration doesn't apply in this situation due to the fact that that tenant is a nuisance. In that situation, the matter would be expedited, as it were, but the court would first have to determine whether or not your case meets the legal definition of a nuisance matter.
So when you bring that action to the court, are you bringing it by any special proceeding, or are you just doing the basic proceeding for a rent for possession with a supporting affidavit?
Right. There would be language within your petition that states, there's going to be language in the affidavit that's submitted by the landlord that states that the hardship application doesn't apply in this situation due to the fact that the tenant is creating a nuisance. Secondly, in the petition itself, you would have to give some description of the nuisance which is occurring by the tenant themselves.
And when you put in have you been getting expedited hearing dates? And if so, what's the turnaround time from filing to a court date?
To be honest with you, to me, the standard that you have to meet to show that the tenant is a nuisance is very high. So in my counseling of many of the clients that I've met with, I haven't had a case that met the threshold that I would say, okay, this is definitely a nuisance. So in actual practice, I haven't done any nuisance holdovers as yet. And speaking with a couple of the attorneys that I work with, many feel the same way. It's not so much a high bar, but this is basically newer legislation, and it's hard to actually say, well, this case is going to meet that definition.
Thank you. At this time, I want to invite Ms. Christy Ortiz-Lapp from the Brooklyn Legal Service Corporation A to give us some guidance from a tenant's perspective on how to deal with rent arrears, court action, and possibly eviction. Christy, you're muted. Let me allow, host, can you please unmute Ms. Ortiz?
There you go. Sorry about that.
Thank you.
Okay, so I am from Brooklyn Legal Services Corporation A. I just wanted to give us a little information about what we do. We currently are open for business, and we're filing emergency applications in housing court that include illegal lockouts, as well as HP actions for repairs that are needed in the apartment. We advise tenants on a range of housing issues. We file fair housing complaints. We also advise newly formed tenant associations and also form tenant associations. And then, of course, we're still defending eviction proceedings, holdovers, and non-pays. So just going to talk a little bit about the more, if you are actually suffering from financial hardship. So there's a number of different resources that you can apply for. The first is the one-shot deal. A one-shot deal is a subsidy that you actually get from HRA. You have to show future ability, and you have to show some sort of hardship as to why the arrears have accrued in the first place. You have to prove that you have the income sufficient to be able to pay the rent going forward, and then you can apply. You do not need to have an eviction proceeding against you at this time. That actually was taken away. So anyone right now who owes outstanding rent can apply for a one-shot deal right now. Also, there is, I'm going to put it in the chat for everybody. OTIDA is actually providing a rent relief program, and that is, sorry. So it's with the Office of Temporary and Disability Assistance. I actually just put in the website so anyone can go to the website, and they have a fact sheet, which is actually very informative. So you must make at or below 50% of the area median household income. The aid is for 12 months from March 2020 and can be up to 15 months of rent, but you have to show that you pay more than 30% of your income towards your rent. And so that generally negates NYCHA or HUD buildings. And then there's a preference for tenants living in buildings with 20 or more units, and then landlords can actually apply for the rent relief. It doesn't just have to be the tenant. And as Terry was saying, if the landlord accepts the money, they cannot evict you for up to 12 months, so in essence giving you a lease for a year. And if they don't accept the money, they're again prevented from seeking the money in a money action or a judgment. And so then that's a defense that you can raise in your eviction proceeding if they bring it. So for the moratorium, there's currently a moratorium on evictions if you file the Hardship Declaration as per the CEEFPA law that was passed in December 28, 2021. The Hardship Declaration should be sent to the landlord and also the court. I included a link to the PDF for the hardship. You could also go to the court's website to see that, or you can reach out to our office and we can provide you the Hardship Declaration. But as Terry said, if the landlord actually wants to start a case against you and serves you a termination notice, a rent demand, they have to include that Hardship Declaration. And so once you receive those documents, you sign off on that, and that clearly states to the landlord that they cannot commence the case against you until August 31st. So the declaration asks if you are suffering a financial hardship or if you're moving would pose a significant health risk. If either of those two things apply, then your eviction, housing court case are stayed until August 31st, and the landlord can actually start a case against you. If you actually do have a court case that was started prior to COVID, meaning March 2020, or was commenced after March 2020, they could actually bring the case to court if you didn't file a hardship declaration. And the proceeding is generally stayed. However, if you have a judgment and warrant against you, meaning you signed a stipulation, you defaulted prior to March 2020, they can actually continue with the case, but you cannot be evicted until August 31st. And so it just basically stays the execution of the warrant. And then CDC has also issued a moratorium on evictions, but that is only until June 30th, 2021. That also has sort of a hardship declaration, and the standard for that CDC moratorium is a bit more complicated, and it has more criteria, and most of them are dealing with finances. So in regards to the courts, which Judge Gonzalez can speak to more, the courts are entirely all virtual except for if you're unrepresented and you do not have access to technology. There are opportunities in 3 different parts, the HMP part, Part Z, as well as the CAP part, which allow you to come to the 2nd floor to appear virtually. But it's not virtually, you're in person, but you're kind of like sent to the universe to attorneys that are virtual. But you can come in person, but I believe the court will tell you it's preferable that you don't. You actually use the link on Microsoft Teams. Also, the courts are processing only non-payment cases to attorney cases and nuisance cases. Any non-payment cases commenced after the start of COVID where a tenant is not represented by an attorney will be assigned an attorney. So going forward, under the universal right to counsel, every tenant in housing court should have the right to get represented by counsel. So that's my little spiel. And then also, if you guys are looking for alternative housing, there is a program called Housing Connect NYC. I also added the link in the chat. You can apply for different lotteries and different alternative housing. And then, but we don't specifically help with that, but there's a lot of community-based organizations that will be able to help you with that. So that's it for me.
Awesome. It's a lot of information. So if you're listening, please review the links in the chat. If you're a tenant, Christy has given lots of resources that you can use to access funds to alleviate the arrears of rent. So I would encourage you to follow the links in the chat and try to take advantage of those opportunities. Now, I just want to ask Christy, if you're a tenant and you receive a notice for rent demand, what is the best course? Is it best to send that hardship affidavit or do nothing and wait until you get a court petition?
So what we've been suggesting folks to do is just generally reach out to legal services, because we can actually put in for a one-shot deal right away, and that would actually prevent the eviction proceeding started against you. And then there's a lot of different charities, which I didn't include. I sort of have a Word document with a lot of charities around the city that are providing services as well. So you can reach out to legal services. You can actually call 311 and they would refer you directly to a legal services provider. Or you can go to HRA, apply for a grant, or seek out rental assistance in a lot of different charities. So I wouldn't just say hold out and wait. The reason I'm saying that is because when their arrears get to a certain point, whether it's more than 15,000, more than 20,000, it is much harder to get assistance. So if you have a small amount of rental arrears that are outstanding, it is better to kind of resolve it sooner rather than later. But of course, definitely file a hardship declaration if you have been impacted by COVID. That is your right under the law, and that will stay the proceeding until August 31st.
Awesome. So if you're a small business and you receive a rent demand from the landlord, would your organization offer assistance to small business owners?
Yeah, we actually have a unit within our organization that negotiates leases as well as deals with getting different types of subsidies and grants and things like that. So you could reach out to our organization and we can assist you.
Is there any financial restriction on individuals who want to apply for any benefits with your organization?
So for our organization, it is 200% of poverty, but we have been given a waiver of that. And so if we feel that your case would benefit from an attorney, we could actually get a waiver. And so the income wouldn't matter. As long as you don't make like $200,000 or $150,000 a year or something. If it's reasonable, then we can help you.
Awesome, thank you. So there are lots of resources that are available for tenants, whether you're a small business owner, if you have rent issues with your landlord for your rental, Brooklyn Legal Services Corp. A is here to assist you. Feel free to reach out to them on their website. Um, and finally, I want to invite Judge Gonzalez, supervising judge of the Kings County Housing Court, to provide perspective from court from a court viewpoint on how these matters are being dealt with in court. We have both the actions for arrears of rent and we have the actions for evictions, if it commenced prior to March of 2020. So Judge, can you give us some insight on what has been happening and what we can expect going forward in light of the moratorium?
Thank you. Good evening, everyone. As Ms. Ortiz-Lamb said, the hardship declarations prevent us from hearing cases. Some cases, if there's no warrant in the case, then we can't hear the case until after August 31st. However, if there has already been a warrant, then the case can be heard, but no eviction can take place until after August 31st. In housing court, we hear 5 different kinds of cases. We hear non-payment cases, which we talked about tonight. We hear holdover cases, which are cases that are seeking possession of the apartments. We hear harassment cases. Harassment cases are cases in which the landlord is threatening, withholding services, violence, removing doors. We hear HP cases, which are cases for repairs. Those cases are brought either by the city or the tenant. And we hear lockout cases, in cases where people feel that they were removed from possession wrongfully. The landlord, you've been living there for more than 30 days and the landlord changes the locks or throws your stuff out. And since the pandemic last March, we've heard more HP cases and lockout cases than I think we ever have. It's been really rough in those parts. And as a matter of fact, in the HP part, we had to split it into 2 parts because there were so many cases. So right now, we're hearing the lockouts, the HP cases, the harassment cases, and we're also hearing new cases that were new non-payment cases that were brought since June 2020. Those are cases that are being heard in the CAP part. And in that part, we have HRA, we have a court attorney, we have the landlord's attorney, and one of the legal services providers. And most of those cases are being discontinued or settled. So the new non-payments, which are seeking rent, eliminating a lot of those cases. The old cases, the cases that we had on the calendar as of March 16, 2020, going forward, we were trying to put those on in another part, which is Part Z. And Part Z, in those cases, a lot of them have not been heard since last March. Only the 2 attorney cases have been heard. So we're putting them on Part Z so that the tenants, just like in the CAP part, there will be a legal services provider there who will be able to pick up the case and assist them. So universal access is providing attorneys for everyone at this point who needs an attorney. We do have some people who refuse them, believe it or not. But the court is making a big effort to have everyone represented. And what that does is that the case can then be heard virtually. Because all of these parts that I'm talking about, the tenants are able to come in if they, as Ms. Ortiz said, if they don't have access to technology, they can come in and appear in person. And there's a big screen where they can see everybody else appearing virtually. So we have Part Z, where we have nuisance cases and the old cases. We have the CAP part, And then we have the HMP part. The HMP part is the part in which the landlords are asking to execute on their judgments or to receive judgments because the tenants have made an agreement and didn't abide by the agreement, and now they want judgment for the unpaid rent. And in that part, you can also retain an attorney, and then the part will be transferred. The case will be transferred to a resolution part where it's all virtual. We do have all staff returning to the court on May 24th, which is Monday. However, the parts will remain as they are. Where not everybody can come in and just appear in every part. It's only the parts in which I just mentioned, the CAP part, the HMP part, and Part Z, the HP part. Those parts you can come in if you really can't, if you can't call in, if you don't have access to technology. However, you do have the opportunity to come in and, or if you don't come in, to get an attorney who can assist you. Now, if you receive papers from a landlord regarding a case, you should not ignore them. And if you receive papers, you will also get a notice that tells you that you can call a particular number to get legal services. And that number is 718-555-137. And you will be assigned a legal services attorney. In addition, if you receive papers from a landlord, there are a few agencies that will be able to assist you in answering any petition that you get. You have Housing Court Answers, and their number is 212-962-4795. And Just Fix New York helps tenants file papers in HP proceedings and lockout proceedings. So if you're in a situation where the landlord has locked you out, you can contact Just Fix, and they will help you file the papers, and you won't have to come into court. It's Just Fix, JUSTFIX.NYC. We also have a resource center which provides information for tenants and for landlords and for attorneys. We've been getting a lot of calls from attorneys, and the number for the resource center is 347-404-9043. So there are a lot of resources that are now available for tenants and for landlords if they need assistance. And I advise people to use them because the laws have been changing rapidly. And if you think you know landlord tenant, you have to think again now because everything has changed in so many ways. I don't think that anybody should just take it for granted that they can do it themselves, and they should consult with an attorney as fast as possible. Leave it right there and I'll wait for questions.
Thank you, Judge. Can you repeat the telephone numbers? You had given the number for the court for someone to call once they receive a petition. Could you repeat that number, please?
For Housing Court Answers?
Yes.
That's 212-962-4795.
Okay. And then there was a 718-553 number.
That's to get legal assistance, and that's 718-557-1379.
557-1379.
Mm-hmm.
Thank you. So, Your Honor, we have a question in the chat. Someone wanted to know if a matter had commenced prior to COVID for rent arrears, what can the tenant expect going forward, and can they apply for assistance? Now, I think they want to know if they can apply now for assistance.
Who's the question directed to?
I would direct that question to Christy.
Yeah, so it says if non-payment started before COVID, can they still apply? Oh, absolutely, absolutely. The rent relief program hasn't started with OTDA yet, but it should be by next week, they actually said. So we'll see. But you can always apply for a one-shot deal. if you have future ability and you can afford the rent going forward.
Thank you. I hope that answers your question.
And I think I should add that anyone who applies to for assistance through OTDA, their case will be stayed until there is a determination on your application. So it could be stayed longer than August 31st.
Okay. So if the person applies and they present proof to the court that they have applied, then those matters will be stayed, or is the hardship declaration sufficient to stay the matter?
No, they're two different things. The
Okay.
hardship declaration does stay the case until August 31st at this time. However, the assistance from the application for assistance, people can apply for assistance from different sources. I believe OTDA's funding is funding from the state and federal government. And that will stay the case until the determination is made, or until the application is denied, I believe, is the language I heard. However, if you apply for a one-shot deal and you don't apply for assistance through OTDA, then if you file and have hardship declaration, the case will be stayed until August 31st.
Okay, thank you. So it's critical for you to file the hardship affidavit in every instance.
Yeah, if the landlord sends you a rent demand and you file the hardship declaration, the landlord can't file the case.
Okay, that's very good information to know. At this point, is the court hearing any proceedings with respect to rent arrears, or are most matters stayed?
Well, we do, as I mentioned before, we have the part in which we're hearing non-payment cases that were filed from June last year to now. And in that part, we're finding that most of the cases are discontinued. For the rent has been paid because the tenant has probably applied for assistance, because when the landlord files serves the papers, they serve the papers with a lot of information that gives tenants information on how they can proceed to get funding, how they can get legal assistance. And apparently people are using the resources that are offered to them, and the cases are being settled. So we are hearing the new ones. We're also hearing the old ones in which there's no hardship declaration.
Okay, awesome. Well, thank you, Judge. I really appreciate that. So if you're listening to us and you have questions, please drop your questions in the chat. If you're on Facebook, please feel free to message us there on the WeActors website. I also want to acknowledge Judge Dwayne Paul. She's one of the judges that also sits in the Housing Court in King's Civil Court. She's also an attorney, and she has practiced with respect to commercial landlord matters as a judge. So I want to invite Judge Dwayne Paul to speak briefly. She is currently running for the position of Surrogates Court for Kings County. So Judge Dwayne, I want to invite you to say a few words at this time. 1 second, we will unmute you. Host, can you please unmute Judge Dwayne Paul?
So there was a quick question in the chat while we're waiting. The question was, are landlords also provided attorneys? They are not. It's universal access for tenants.
Okay.
Okay.
Thank you so much. Hello, everyone. Good evening. Hello, Judge Gonzalez. I think we might both still be here, working late hours. What an amazing opportunity for the West Indian Day American, the West Indian American Day Carnival to put this program together so that we could all be educated and stay connected. And so we also, I'm a civil court judge now in Brooklyn, and we do some landlord tenant related cases, but only for commercial cases and only if the tenancy is broken. So if there's an issue where there was a landlord tenant relationship and there no longer is a landlord tenant relationship because a tenant has moved out, but there's some residual legal issues, maybe there's unpaid rent, or maybe there's some property damage, they can come and file in civil court. And we also do commercial landlord tenant to the extent that there's a business that has a dispute, some landlord tenant issue with the commercial landlord. So those cases come through here. And as she mentioned, I'm a candidate for Kings County Surrogate Court. This court is very instrumental to the community. It's oftentimes, though, we've never heard of it. And a lot of times, even if you're an attorney, you may not know the full intricacies of what happens in surrogate's court. But it's a place we go when our loved ones pass away, whether they had a will or they didn't, and we make sure that all of their assets and everything they worked hard for gets from one generation to the next. We also do guardianships of mentally disabled adults, guardianships of minors, and adoptions. I'm really passionate about this court because, especially now with the pandemic and the amount of people who passed away in Brooklyn, you know, there was a time we didn't even get a chance to say goodbye to our loved ones, much less plan for death. And so surrogate's court is instrumental to making sure that our communities hold on to their wealth. And I started in family court. I was an acting Supreme Court justice there for 4 years. I'm in civil court now. I hail from Bedford-Stuyvesant, and I'm hopeful for an opportunity to have your support. And I'll put just information in the chat of how we can stay connected and find out more information about the campaign. The election is June 22nd. It's a countywide election, so no matter where you live in Brooklyn, poll for surrogate will be on the ballot. Keep me in your thoughts. I'll put information in the chat. Thank you so much.
Thank you, Judge Paul. I appreciate. Thank you for coming out, and good luck.
Thank you.
Upcoming elections. Awesome. So we were honored to have Judge Paul join us and give us a bit insight on her experience with regard to commercial matters. Going forward, if you have any questions, please feel free to put it in the chat. Whilst we wait, I want to personally thank the panelists for joining us. I know we started a little late, but we were able to deliver the most precise, pertinent information relevant to the topic. And I want to say an extreme heartfelt thank you to all of you. Ms. Ortiz Lam, your organization, Brooklyn Legal Services Corporation A, is a resource that is, you know, unheard of. I mean, the amount of things that you addressed, I wasn't even aware of all the resources that are available to tenants, and to know also that small businesses can access assistance in this economic downturn. So I would encourage everyone to visit the website or to send an email. I think it's info@bka.org. If you have any questions about how Brooklyn Legal Services can assist you, if you have a pending matter in court and need legal assistance, or you need financial assistance from a rent or rare perspective, please reach out to Brooklyn Legal Services. And if you're a landlord and you need assistance with regard to getting that rent from your tenant and defending any claims in court, I encourage you to reach out to Mr. Terry Hines. He's knowledge and experience in landlord and tenant matters, and he is based in Brooklyn, New York. He has an amazing Caribbean heritage. I think his family is from Barbados. And he is based in Flatbush area on East 42nd Street. He has a website, Terry, I think it's the Hines Law Firm. Please Google it, give him a call if you need any assistance. I'm sure he'll be very willing to assist you. And I want to thank again Judge Gonzalez for her knowledge and insight with respect to what's going on in the courts. I want to reiterate that if you file the hardship declaration for matters that are pending or haven't even commenced, those matters are stayed until August 31st of this year, and that's by executive order here in New York. The judge also highlighted that there is another way to obtain a stay if you have applied for financial assistance to one of the agencies. It doesn't necessarily have to be Brooklyn Legal Services, but there are a plethora of other organizations that can provide you with financial assistance in this time. If you have a pending application and you can present proof of that to the court, Judge Gonzalez has indicated that those matters also will be stayed up until there is a determination on your application for financial assistance. So thank you, Judge, for enlightening us on that.
I just want to say only applications to OSADA stay. Yeah, the other applications, you would need a hardship declaration.
ORTIDA. Yes, ORTIDA is open for emergency rental assistance, and they're the ones that would give up to 12 months of assistance from March 2020.
And their website,
thank you, Judge.
It's not quite open yet. I think maybe by the end of this month.
Okay.
They're working on it.
Yeah.
But I think they have put up something on the website. So folks should.
There's like a fact sheet. There's a fact sheet on there, and it literally says we just did a training. They just did a training on it, and they said about a week or two before it'll be released.
Awesome. So I think that's the best news for everyone. If you have arrears of rent, the application for financial assistance will be open through ORTIDA. And if you have a pending application, it will serve with ORTIDA, it will serve to stay those actions for rent arrears. Please bear in mind also that at this time, there are no evictions being granted by the courts in Brooklyn and also by extension, New York City, Queens County. If you
That's not entirely correct.
Well, generally. Yes, Judge. I don't know if you want to touch briefly on that because
well, if there is no hardship declaration, if there is if it's a nuisance case, you can be evicted. If you haven't filed a hardship declaration, or if it's a nuisance case, the evictions are permitted.
So we had asked the landlord's bar about the nuisance. Have you seen any nuisance applications being filed to show that the tenant is destroying the premises?
Yeah.
We've been assigned nuisance cases.
Okay.
To represent brand new ones in Part Z. So yes.
Okay, so that's good to know that the exceptions are there for eviction. Generally, evictions are not being granted, but there are exceptions, primarily, as the judge noted, where you file for a nuisance exception, where the tenant is destroying the premises primarily. So that is just a brief summation of the topics that we've covered today. The rent moratorium, again, is in effect until August 31st. I want to thank the panelists for their clarity of presentation. It was very informative, and it went straight to the point in terms of what I wanted to present to the public. This is the Law and You Part 2 series in collaboration with REACTA, and we seek to provide pertinent information to the public about matters of interest. And right now, everyone has been affected by COVID. We're still experiencing the residual effects of COVID. And so it was great to present this forum in partnership with REACTA. I want to thank the REACTA board and management. I also want to thank DJ Spice and Team SOCA for facilitating us as hosts, and for all those other persons who were instrumental in getting us to where we are today. Thank you again, and it was a great pleasure. We will have another forum on the third Wednesday of June, where we will address the topic of the Represent We legislation, which is a pending legislation in New York, which seeks to give immigrants that are not citizens' rights to vote. So please join us for part 3 of the Law and News series, where we present more pertinent information to the public. Thank you. Have a great evening.
Thank you.